Hmm. Can we start?
Yes, yes, we are online. We can start.
Yes, yes, thank you.
Okay. Good afternoon, everyone. Despite these difficult times for all Ukraine and particularly for our city of Odessa, we have to move forward and with gratitude to the Ukrainian army and soldiers whose bravery allows us to continue our work. It is truly an honor and a privilege to welcome you all to today's webinar, English Law in Practice, Contracts and Arbitration. My name is Denis Stadnichenko, and I'm the Business Development Manager at Interlegal International Law Firm. Together with my today's co-moderator, Alexei Remeslo, who is a partner at Interlegal and the head of International Trade Law Department, we are thrilled to bring you this event in collaboration with some of the most distinguished legal experts from leading global law firms. We at Interlegal are proud to play this role of facilitating such a conversation as this one and connecting professionals from around the world. Speaking of the world and geography, I'd like to highlight that the truly international nature of this event. And we are delighted to have more than 170 registered attendees from more than 20 countries, including Bulgaria, Cyprus, the Czech Republic, Emirates, United Kingdom, France, Germany, Greece, Portugal, Ukraine, Switzerland, Turkey, Moldova, Romania, the Netherlands, Isle of Man, India, Kazakhstan, and Saudi Arabia. While not all of you maybe can join us online now, we appreciate your interest and engagement. At the end of this event, I will share details how and when you can get the recording and speakers' presentations. Today's online event is organized by Black Sea Institute of Maritime and International Trade Law and Interlegal, international law firm. Let me briefly introduce these two organizations. The Black Sea Institute is the public organization focused on creating the platform for sharing an experience between maritime and international trade communities focused mainly on the Black Sea region. The Interlegal is an international law firm and with the key practices in shipping, transport, corporate and taxes, international trade, and yachting. We have our offices all over the world, but mainly we are focused on the Black Sea region, and we have offices in Moldova, Romania, Bulgaria, Turkey, and Georgia. And last year, we have set up also our company in Cyprus with our people there. We are one-stop shop in Black Sea region. Moreover, we have more than 60 associated offices all over the world working 24/7. So you're always welcome. Our key numbers, it's already 30 years of practice, 1,000 cases per year, 60 plus experts all over the world, 50 experts at head office, and 50 disputes more than 50 disputes per year, 70% of amicable settlements, more than 25 arrested and released ships per year, and more than 100 yachts under maintenance. With that, let's officially kick off the event, and I will hand over the floor to my co-moderator, Alexei Remeslo, for his opening remarks before we give the floor to our first speakers. Thank you very much for joining us, and I hope you find today's discussions practical, impactful, and insightful. Thank you. Alexei?
Thank you very much, Denis. Thank you. Greetings to all our participants. First of all, I need to say that you are lucky today. Why? Because we have a dream team of our speakers. And let me introduce them, but before that, I need to mention that you are able to ask any questions you want, subject to the topics of our discussion, of course, but please use the Q&A section in the Zoom application, not chat, please. Once again, Q&A section. I will manage these questions and ask them to our speakers. So let me introduce them. The first speakers are Rosie Gonker, partner of Hill Dickinson in Marine Trade and Energy team with experience in charter party, bill of ladings disputes, marine insurance, sales of goods, ship arrests, etc. Together with Helen Tang, barrister of Hill Dickinson. She's a specialist in international commercial and regulatory law with specific experience in sanctions. Their topic is what is default. The next will be Andrew Rigdon-Green, who is a dispute resolution partner at Stevenson Harvard, and he is a fellow at the Chartered Institute of Arbitrators and a member of the Singapore Chamber of Maritime Arbitration. His topic is what are damages in shipping and commodity trade. And the last one is George Lambrou. George is a partner of Keystone Law, an international dispute resolution specialist who resolve high-value and complex multi-jurisdictional disputes. He is a solicitor advocate who spends most of his time involved in arbitration and as a negotiator. Disputes do arise. What to do then? This is his topic. So I think we are ready to start. Once again, let me remind you to ask your questions. Rosie, the floor is yours. You can start. Thank you.
Good afternoon to everyone. I hope you can hear me. Thank you, of course, for everyone for joining and Interlegal for organizing this wonderful event and inviting us to speak. I hope you can see our presentation.
Yes, we can see and we can hear you.
Thank you. Brilliant. Thank you so much. So please accept my apologies from starting with the basics. We have, during our preparation for this talk, and we know that there is very limited time, of course, available for everyone. We just, we reflected on the cases we have dealt with in our wider team in the past, in the most recent sort of months. And we have realized that actually, the key question of a majority of cases we are dealing with actually concern the problems in relation to first, whether there was a contract concluded, and then what were the terms of the contract. So while the topic of this presentation is default, effectively, what was important is to establish the breach of a contract. And in order to do that, of course, the parties, what we discovered, often have very different understanding as to whether the contract was agreed in the first place, and of course, what were the terms of that contract. And in particular, dealing with our clients that are not fully familiar with English law and common law, and the ones particular which that come from continental law countries, there of course they usually expect a fully signed and executed sealed contract before they can think before they can think they are under obligation to perform that contract. And of course, as many of you know, especially when it comes to commodities and international trade contracts, this is often not the case, and the contracts become binding when, for example, the main terms are agreed. What is also different from the continental law, that often in the English law-based contracts, various terms have various weights, in terms of whether what will be the consequences of that breach. And often as well, the involvement of brokers or agents and other intermediaries makes also understanding the terms agreed and the binding nature of the contract more complicated as well. The next, of course, hurdle to overcome is what we often see is basically we see a properly signed contract, and then, of course, something happens, and then the parties start to consider various variations or agreements to change their original obligations. And that's when we often have to deal with, WhatsApp exchanges, Skype exchanges, telephone conversation, meetings, and so on. And I think quite often what we've seen, if the parties think that, if their original contract was, in writing at least, or signed to even better, then they expect that none of those further exchanges have sort of material effect on their obligations. However, English courts have been saying again and again that, oral variations to a written contract are possible and can become binding. Therefore, our warning to all the attendees is that you have to be really careful what you say or write or text, because all of that can be admitted, as evidence in further proceedings. Turning to default and of course the date of a breach, we have on screen widely used terms of contract. And we're sure if you are familiar with the terms and the terms of the default clause, which you find on screen. However, as we have seen lately, that the tribunals and the courts, they often, of course, interpret the terms depending on the specific facts of the case. What is also important is that we very rarely see that the defaulting party sort of admits to the default. Quite often, again, referring back to the variations and exchanges between the party, what we see is that parties, in anticipation of their default, they try to vary the contract, they try to enter into agreements to avoid the default. Therefore, it's very important to understand the full scope of obligation, and as to whether when that party would be treated in breach, not in terms of the time, but also in terms of when they fail to perform their obligations they have agreed to perform. Here you can see on screen the standard provisions, which again serves as a first point of reference to the courts and the tribunals. But I think we wanted to talk now more about specific cases and specific points and decision raised by the tribunals and the courts more recently, which then of course aided and discussed interpretation of those clauses. So first, which is a very recent decision made by the court, is in relation to a Agro-Invest case. And here, as you see as well, and you probably know, again, there was uncertainty about what terms were agreed. Was it sale of non-GMO or GMO goods? what were the terms of prepayment? Was it a deposit, or was it just an advance payment? Was it a guarantee? In the end, I think after all those that time of exchanges, the buyers decided that they did not want to accept delivery, and gave notice to the sellers that the sellers should not ship the goods. And at the same time, the buyers have also requested the return of what they called an advance payment, to which the buyers said the sellers were not entitled. And so in this case, this was a case when it was not disputed that the buyers under this sale contract were in anticipatory repudiatory breach and had renounced the contract. But the issue was whether the date of default for the purposes of the GAFTA contract 100 clause, was it the date of the breach or was it the date of acceptance? After the arbitration proceedings, the case went to the court, and the court decided that the actual date was the date of the breach. The court also found that the sellers were obliged to return the advance payment made by the buyers, which reflected almost 20% of the purchase price, because the court decided that was not a deposit. However, the court permitted the sellers to claim losses by way of damages if the sellers were able to prove that the renunciation and termination of the contract by the buyers have caused them actual losses. So therefore, the court basically discussed those various scenarios, and in this case, the court decided that where there is a case of anticipatory breach, which is then accepted by the innocent party, the court suggested that the default date is in fact the date of the breach, rather than the first day after the delivery or shipment period that is usually relevant one for default price purposes. The judgment itself actually questioned correctness of this conclusion, but the court felt bound by the previous authority, including the Toprak and Fingrade company case. And the court decided, of course, that for this, even if the court felt bound by authority, the decision was made based on specific facts of this case. Therefore, by way of our reflection is that we think that there will be a question mark over this issue, I think, until all that time, for example, when a court of appeal gets examined to this question. And in terms of our advice going forward is particular in cases of anticipatory breaches, which is in cases of anticipatory breaches which are then accepted, it's always to consider putting in an alternative price evidence based on a range of possible default dates. So I will now hand the floor to my colleague Helen, who will continue discussing various default dates. Thank you. Share my screen. Yeah. Thank you. Just.
Hello, good afternoon.
Hello, Helen. We can see, we can hear you. We can see your presentation, but please,
Okay,
please switch on the slideshow. Thank you.
Yes, this. Yeah, it's fine. Okay. Yeah, this one. No, sir. Oh, you want me to? Okay, so can everyone hear me? Okay.
Yes, we can hear you, but Helen, I think you have two microphones, yours and Rosie, maybe, so we can hear the echo.
Now we don't hear you.
Yeah.
Please.
Switch on the microphone, please, Helen. Just a second, friends.
Unmute.
Yeah,
Yeah.
that's fine. That's not, no, it's fine. You get
Yeah,
two
now we can
Now it's
see
okay.
you and now we can hear you. You can
Perfect.
start, please.
Can you
Yeah.
see the presentation as well?
Yes, Rosie, everything is okay, but switch on the slideshow mode.
Okay. If you don't mind, we'll share the slides with you afterwards, if that's okay. It just helped me with my presentation.
Yeah, okay.
Yeah.
Okay. Great.
Okay, so phosphor. So you've just heard a moment ago about GAFTA. So phosphor in many ways is actually quite similar. It's under Form 53, and the contract is for vegetable and maritime oil. And the clause that you're looking at is clause 26. It's actually quite a chunky paragraph, but I would like to break it down for you in 4 parts. So firstly, in relation to default, it's a question of 1, giving notice, deciding to cancel the contract, or whether the right to sell or purchase, and making a demand for the good of the loss. And secondly, the damages of the defaulter normally is the difference between the price of the contract price, in other words, the actual estimate price on the day of the default. And thirdly, the arbitrators often have the chance, upon their own discretion, whether that they will vary that. So that is something that's worthy of noting. And lastly, some of you may or may not have noted this, but actually, both parties, so either party can notify the other party of its inability to deliver or take, but the default date cannot be without the agreement of the other party. So you see, whilst on the face of it, there are many elements with which one can claim default, but in essence, you need an agreement. So let's explore some of the scenarios. So for example, you will see, there are scenarios such as a failure to deliver goods. Now, this makes sense. You have a seller that doesn't deliver on the contractual basis at the time that they say they would. Or you might have a scenario where there is a failure of payment. They may not pay elements at the same time. Or you might have rejection of goods. Goods may be delivered, but not to a satisfactory level. And there might be non-compliance with specifications. You might have technical items or items, let's say you wanted yellow beans and, it becomes something else. Failure to load or discharge the cargo. You might have scenarios where, for various reasons, because of weather conditions, because of, technical reasons, they are unable to disload, or maybe even they don't have the manpower. Now let's look at next, well, what are the consequences? Well, as a consequence of that, there are rights to damages, which I believe one of the other speakers are going to talk about. You can either cancel or terminate the contract. You can resolve your matter via arbitration. And again, we go back to the default clause. Now, what does it mean? What does non-performance mean for you as a party representative, or for you acting for a client? Well, from the seller's perspective, and again, this is really important, depends on which side of the fence that you're looking at. So for the seller's perspective, it might be a failure to see delivering of the goods. And as such, it's not meeting the delivery time, the quality, specification. And from the buyer's perspective, it might be failing to pay for the purchase product based on the contractual requirements. Now, when there comes to specific breaches leading to default, you might see scenarios of not tendering the shipping documents. You might have scenarios where there are incorrect or invalid, bill of ladings and other CIF documents. Or it might be failing to meet certain deadlines and shipment deliveries. Or it could be failure to comply with conditions on a contractual basis. Now, you might sometimes see a repudiation of contract. So either party declaring that they will no longer perform the contract. And that is also triggered under clause 26 Now, you might think, well, what other matters could there be? In essence, if you think about it, if there are material failures to perform the contractual duty, then that would be enough, in essence, you could say, for the default to get triggered in. Now, so then your next question might be, so when does default? And I think this is probably one of the interesting questions that are asked.
Apology.
Yes.
Which slide? Can you tell me, because I'm in control? Can you?
I think they can actually see. I think they can actually see my slide.
Yes.
Yeah,
Okay,
yeah, sure.
perfect. Thank you.
So for
Yes, we
example,
see it.
When exactly does the default occur? Now, there are a few scenarios, right? So you can have on the day of the delivery, the shipment date, if the seller fails to basically ship the goods on the date, you could say, well, the default occurs right away. Or it could be upon document tender. So the goods are shipped, but the documentation is not ready. You could say payment date. Well, you would hope that payment is, due upon the delivery of goods, but that might not be forthcoming. Or you might have an anticipatory breach. In other words, the default may not have happened, but the circumstances allow you to see it may happen. So in various cases in case law, there are strikes, tsunamis, COVID, you name it. There are many potential scenarios where parties may want to trigger, for example, force majeure. So it allows you a level of creativity in thinking, well, what kind of scenarios can come to play? Now, let's imagine for a second, there is a default. So what are the practical aspects of it? What are the remedies? Now, certainly someone could argue one can mitigate the loss, but let's be honest. In practice, it's very limited what one can do. In a normal course of business, a default is usually not very clean and clear cut, if that kind of makes sense. Businesses are in conversation. They want to get the deal done. They want to negotiate payment terms and get the documents in. So notwithstanding, we say, you might identify a particular date as default. It's often not very clear. Now, notice of default is important because in essence, you are officially saying something is wrong, payment is not being made, or delivery is not forthcoming. And the party on either side is telling the other side they have breached and therefore outlining the consequences of that. So one of the cases I wanted to touch upon is for Bremer Handel and Van der Reen. Sorry, my pronunciation isn't great. But in essence, that case, it was a House of Lords case, and actually it was under the terms of GAFTA, but the essence is the same. It concerns anticipatory breach and the right to terminate the default. So in the facts of that case is that Bremer agreed to sell feed barley to Vanden under the CIF contract with the delivery spread over multiple shipment periods. The contract included an arbitration clause and a prohibitive clause excusing performance in the case of events like export bans. Now, before the first shipment, the German government imposed an export ban. How convenient. So Bremer claimed that the contract was frustrated and refused to perform. Vanden treated this as a repudiatory breach, in other words, an anticipatory breach, and sought damages. So what were the legal issues? Number one, did the export ban frustrate the contract? And secondly, did the seller's refusal to perform amount to an anticipatory breach or default? And in that particular decision, the court held that the export ban did not frustrate the contract and that the seller's refusal under the contract constituted anticipatory breach. Now, the arbitration clause remained enforceable even though the contract was terminated. So there are a few key lessons, and of course, there's another case I can also refer you to, and it's called Toprak and Vinaigrain Champagne Commercial. And in that particular case, the Court of Appeal addresses the issue in a dispute under a CIF contract for the sale of grain. The case explores default, anticipatory breach, and the role of contractual obligations. So the facts of that case is that Toprak entered into a CIF contract to sell grain to Vinaigrain, the buyers, and under the CIF contract, the sellers were obliged to ship the goods and tender conforming documents, i.e. bills of lading, insurance certificate, and invoice within a specified time. The sellers failed to ship the goods by the agreed time, and instead they basically sought for tender documents that were unrelated to the shipment. Yes, it does happen. And the buyers refused to accept the documents, asserting that the sellers had defaulted on their contractual obligation. What were the legal issues there? Well, one, did the seller's failure to ship the goods and tender the proper documents constitute a default under the CIF contract? And B, were the buyers entitled to reject the documents and treat the contract as repudiated? Now, the decision was that, one, the default by the sellers. So the court held that the seller's failure to ship the goods actually constituted a fundamental breach. The buyer's rejection of the documents, so the buyers were entitled to reject the documents because it didn't relate to the goods at all. And thirdly, in terms of obligation to ship the goods, so the seller's attempt to constitute the documents for actual performance was invalid. So here we have a few key things that you can learn from these cases, that documentation is very important when it comes to the shipping and delivery of goods. And secondly, non-conforming documents, in essence, is a breach. And anticipatory breach can be a default. And there's also buyer's rights in the default. Now, so in conclusion, although I did speed through it quite quickly, there are a few key things I'd like you to take away from this point. Anticipatory breach constitutes default. Therefore, it's really important in your correspondences, in your notices, in the way you're communicating, and we appreciate a lot of parties now communicate on WhatsApp, that you keep photo images of such correspondences, that probative causes are limited, again, such as mitigation. They're very, very limited circumstances. Obligations persist unless excused. Why do parties have contracts? The view of contracts is to create certainty, is so that parties can do business together. And again, I emphasize mitigation is limited, but most importantly, very often than not, to trigger the default clause, ideally both parties are in agreement. And as we all know, very often it doesn't happen. And that, I don't know, I'd like to maybe acknowledge our other partners. So Rosie spoke, Darren, our other partner, he was going to join us as well. Unfortunately, he couldn't join us. He also contributed to the presentation. And we have Virginia, also our associate who contributed. I don't know, I think that's the end of my presentation. Yeah. Of course, you can find out more information about the firm online as well. I think we have some time for questions if there are any.
Rosie, Helen, thank you very much. Very useful presentation. And of course, we have some questions to you. Some of them I have in Russian, so I will translate it. First one, what is the consequences in case of no providing of the notice of appropriation in CFR contracts? I think it's about GAFTA phosphor performance. What can you say? Non-providing of notice of appropriation from seller's side.
Okay.
What is the
You
consequence?
say like inappropriate documentation?
No.
Non-providing of notice of appropriation in CIF contracts from seller's side. What is the consequences?
So let me just put it on. Yes, so I think what is important as to whether or not, of course, the standard GAFTA contracts have been incorporated. And this will be, of course, determined whether, which party is in breach and whether the notice has been properly sent and the cargo allocated to the particular transaction, and which will also be then have effect on the date on when one of the parties will be held in default. And I can just quickly go back to the our presentation, which was set out exactly from GAFTA 48. And as you can see, so in the case, if default has not been already declared, then if notice of appropriation has not been served by the 4th business day after the last day of appropriation laid down in the contracts, the sellers shall be deemed to be in default, and default date shall be the 1st business day thereafter. what we've also seen in practice is that if there is no notice of appropriation have been sent, again, that is casts some doubt. For example, if the sellers were actually ready and able to ship the goods, and whether they were committed to perform the contract, which of course, becomes quite relevant. For example, if there were changes and variations discussed between the parties, after conclusion of the agreement. And therefore, for example, in terms of, Ukrainian traders as well, we sometimes seen that sometimes the problem is that the cargo is not available. Sometimes the problems of for shipment is because there is no vessel, for example, that would be available to ship the cargo. So again, the sellers have to be prepared to show that they have always been ready and able to perform the contract, and therefore they have to basically make sure that they take all steps necessary for them to show that they can perform the contract, and therefore they would be entitled. They have performed their part of the deal, so to speak.
Thank you, Rosie. Clear. The second one. We have FOB back-to-back contracts where we are sellers and buyers at the same time. What clauses you will recommend to check, amend, or do something else to minimize our risks? Very practical question.
Yes, I think the standard sort of reply would be, if you could send us to your standard templates, and we were happy, of course, to review them. However, of course, if you are a FOB seller and you are based in Ukraine, then one has to be sure that you have cargo available, and that any sort of course, internal problems of shipment, of loading, that all those problems are addressed, and that that the sellers leave themselves room in terms of their rights, or some sort of the rights and ability to adjust, for example, the dates in terms of performance of their obligations, because of course it's impossible to predict everything. And unfortunately, of course, we have just surpassed, a very sad anniversary of the war. However, that also brings into perspective, the parties' ability to perform the contracts in view of course, the war continuation, and in a way, claiming difficulties, or claiming, asking for an excuse, so to speak, no matter how sad it sounds. I think, the foreign buyers are quite often ruthless, and they are not sort of prepared to give any sort of flexibility to the sellers, from Ukraine, and therefore often want to hold them to the contract, and are not reticent to terminate or hold the sellers in breach.
Thank you, Rosie. The next question or comments, I don't know, from Jeffrey. Thanks to Rosie, but I noticed one of your comments and would be grateful for your clarification.
Yes.
Under English law, are phosphor or GAFTA contracts not the same as other contracts, shipping or trade? Is that there is no contract until all details, not only main terms, are agreed and all subjects have been lifted?
It really depends on the agreement and what the parties have agreed. But I think the understanding in terms of commodities contracts is that the conclusion is often based on commercial thinking of the parties. And I'm sure all the parties who have been to arbitrations, for example, in FOSFA and GAFTA, they have seen that the tribunals who are basically mainly formed from the trading professionals, they are much more readily prepared to infer the agreement being made and being a binding agreement being made by the parties in terms of commodity contracts. Because, for example, when compared with shipping, yes, we very rarely see, a very short charter party, for example. Still, there are lots of terms in the recap which need to be agreed with the incorporation of charter party before the agreement, before the decision is that the agreement has been formed. However, what we've seen in practice when it comes to trade contracts and basically going back to the case, the recent case I've just mentioned, here, the contract was held to be binding, even in the situation where there was still a dispute between the parties as to whether GMO or non-GMO cargo was to be sold. So there were still uncertainties between the parties as to the exact terms of the agreement, but the court and the tribunal decided that there was a binding contract. So I think there is this additional flexibility which is added sort of factor in terms of the commodities contracts, which we rarely find in other sort of contractual relationship.
Thank you, Rosie. And two last questions.
We're popular. That's good.
Yeah, you're very popular. For example, if we have one contract, phosphor or GAFTA, but we have different 3-4 shipments. In case of breach of first, for example, shipment, can it lead to the default of the whole contract or only for the first shipment?
I think that the answer here in particular really depends on the wording of the contract and as to whether it's parcel sale or there is like a whole lot sale and how it is determined, because and again, going back to the start of my presentation, where we discussed about the different weight of the terms that are set out in the contract. Some of them are intermediate in nominal terms. Some of them are held to be conditions of the contract. So, for example, if there is a specific shipment date, a specific parcel, and the contract is very specific, then the effect of the breach could be held as going into the root of a contract. However, depending on, as I say, how specific the terms of a contract is and what is the actual effect of non-delivery of one parcel, and whether it entitles the whole of a contract to be determined as sort of, how to say, not terminated, but affected significantly and so seriously that the performance of the contract as a whole is to be treated as impossible, for example, or breaching and damaging the counterparty's rights. Again, that's very difficult to comment. So I think the more specific the contract and the terms, it then entitles the party relying on the contract to point out to those specific breaches and seek remedies as a result.
Thank you very much. And Rosie, I think it will be the last one because I see that something is typing another question, but we have limited time. So the final, it's also in Russian. I will translate. So we have a CIF contract from one of the Black Sea region ports. And what do you think in case of damage of the port or railway station, will it be the force majeure for the seller's side?
So before shipment or
So shipment from, okay, for example, shipment from Ukraine, from one of
Yes.
the Ukrainian ports on CIF basis, and during the shipment, some rockets attack the port infrastructure, and the seller is not able to load the vessel.
Oh, I
Will
see.
it
So
be the
before
force
loading.
majeure? Will it be the force majeure for seller?
Yeah, so that's what I've already touched briefly, I think, Alexei, isn't it? That of
Yeah.
course, if if it is, if the seller's duty is to ship, isn't it? And the seller's duty is to load the cargo on the ship the seller chartered, under these terms, and it's difficult to say that if the event was such that it completely prevented the seller from performing of their obligations, then it may be claimed. But as I mentioned already, because of continuous war, I think it will also be very dependent as to whether, for example, the seller only took care to ship like a day before the shipment period ends, or whether the seller actually took some steps in advance. But if the seller left it, we had a few cases where the sellers left it too late, or for example, the vessel they chartered did not arrive on time. Unfortunately, quite often, this is the seller's obligation, and of course they are under obligation to ship the goods within the determined period, which then puts them at risk. And of course, that under English law, a mere sort of certificate of force majeure event will not necessarily help. And I think we already probably discussed with you the force majeure clauses and in GAFTA context as well, that prevention of shipment clauses, yes, they may assist the parties, but I think the test for force majeure is always as to whether that event was not anticipated and could not have been prevented. So any events would have to still withstand the test of English law.
Rosie, Helen, thank you very much for your presentation. Thank you very much for your answers. We will share your contact details, your presentation, together with the video records of this webinar with our follow-up to all participants. And thank you very much once again. We're ready to move forward to our next topic. Let's speak about damages. And
Thank
our
you.
next speaker is Andrew Rigden-Green. Andrew, the floor is yours.
Thank you very much. Let me start sharing my screen, and we'll get to present mode. Yeah.
Yes, we can see your slides, but please switch on slideshow mode.
Yeah.
Yeah, perfect.
And okay. Are we still good?
Yes,
all there?
everything okay.
Okay, brilliant. Fantastic. Well, I'm struggling to follow Rosie Rosie and Helen, because they did such a great job looking at breach. And of course, there are so many ways in which contracts can be breached. Fantastic job. I'm absolutely delighted to be able to join you again. It's been a long time since I've been able to join you in Odessa, so it's really nice to be able to join via the web. As you'll see from this slide, I'm actually based in our Hong Kong office. I'm an English lawyer and a Hong Kong lawyer, and continue to practice both English and Hong Kong law within the shipping and disputes practice. So today we don't have a lot of time, but there are a number of topics that I would like to cover. So we'll see as much as we can. I think it's really important to have an understanding of the general law of damages before we ask the specific questions, because in each circumstance, the amount of damages or the measure of damages will change according to the facts of the situation and the degree of the degree in which there is a breach. And there's this leading textbook on damages, which is about this thick, called McGregor on Damages. It deals with all kinds of damages, whether in shipping and commodities or in other areas. But there's this lovely quote, which I quite like, where it says that damages are often underrated and people don't consider them in detail before they start their dispute or they start shouting about breaches. Damages are extremely important, and understanding what kind of scope of damages you have would be really informative to know whether actually it's worth starting a dispute, and whether you'll be able to recover any of these damages, and what kind of scope of damages you might be able to obtain. So we're going to look at the general principles. And firstly, because we're talking about trading contracts and shipping contracts, of course, there are contractual damages. And contractual damages are different from non-contractual damages, and that's why I'm making a distinction here. And the purpose of damages is something that you really need to remember when you are starting to think about any claim. In a contractual context, damages are put in place to try and put the innocent party in the position that they would have been in if the contract had been performed properly. So the consequences, it's to correct the consequences of the breach by the guilty party. And of course, the more serious breach would entitle the innocent party to even terminate the contract, regardless of what the nature of the breach is. The innocent party will be entitled to money compensation. Now, of course, if that principle is pushed to its extreme, it could end up being a very harsh measure. If you look at every single natural consequence of a particular breach of contract, that could, in fact, entitle parties to a massive amount of damages, and the guilty party may have only committed a small breach. So there is a principle, of course, of causation and remoteness. So when damages are claimed by someone, they must be for losses caused by the wrongful act. And I've put this old mill, this factory, up, a picture of it and the name of the case, which is obviously quite old, because it's still the leading case on what is too remote, what is too far away from the incident to be properly considered to be a loss that can be recovered for. So in this case, Hadley and Baxendale, the claimant was a miller. So they had a flour mill, and they needed to have the mill shaft repaired. So they contracted with Baxendale to carry the mill shaft to the ironworks and bring it back. The shaft was delayed in transit, so the carriers delayed bringing the mill shaft back because they were negligent. and the mill lost 5 days of production. And so the mill claimed for its lost profits. And it was held that damages would be allowable for anything that is fairly and reasonably in the contemplation or to be considered to arise naturally from the breach of contract. The total stoppage of production, the court held, was not something in the natural consequence of delay. So the court said the kind of damages that you can claim are those that are naturally arising, and a stoppage could be naturally arising, but they said it was not necessarily in the contemplation of the parties at the time that they entered the contract. So there are other solutions. The mill could have, for example, had a spare shaft in stock, and so it wasn't reasonable to expect the carrier to be aware of special circumstances. Having said that, if the carrier is aware of the special circumstances, so when the mill owner had said, hey, I need you to get this mill shaft to the steelworks to be repaired really quickly because I've got no other mill shaft. And if I have to stop production for 5 days, it's going to cost me an absolute fortune. Then in those circumstances, those what they might call special damages could be claimed. So it's really important to bear in mind when thinking about damages that there is a limit to the amount of damages that can be claimed, but there are circumstances when those extra damages might be something that is claimable. The other principle that is often talked about, and it was mentioned in Rosie and Helen's talk, was mitigation. And you often hear, particularly guilty parties, saying, oh, this person can't bring a claim against me. They must mitigate their loss. And once they've mitigated their loss, then it's all over. There's no loss. Now, we've got to remember that this so-called duty to mitigate is not, in fact, a duty to do anything. So it's not that the innocent party must take certain actions, but it is a way in which the innocent party's damages might be reduced a little, and the court or the tribunal will assess whether the steps that are proposed by the guilty party, saying, oh, you should have shipped it here, or you should have carried this grain, or you should have accepted euros in payment instead of US dollars, those kind of steps, they are limited. So they must be the steps that a reasonable and prudent person would take in the ordinary course of business in order to minimize the loss that they suffer. So the idea is that it's a limit on the amount that can be recovered, but it's not necessarily a duty to do anything. So those are the basic of contract. And what about tort? And is tort even relevant in a situation where we're talking about claims in contracts in trading contracts and in shipping? Well, firstly, let's talk about what tort is. Tort is a duty that arises between parties, even though they have no contract. And two particular ones that are very relevant to our industry are the tort of negligence and the tort of conversion. So the tort of negligence is, of course, a duty to perform any particular act with due regard for those people around you. So a duty to do. So if we're talking about a driving situation, for example, your duty is to drive correctly and not to drive on the pavement, on the sidewalk, for example. So that is a very clear example of negligence. the tort of conversion, now that is a more interesting and a difficult English word, but the tort of conversion means that the duty not to use somebody else's goods for my own economic benefit. So it's a little bit like stealing, but it's not a criminal offense. So if we imagine it like that, then we can see how it might be a different situation. So, for example, if you are in possession of a part of a cargo that has not been collected by a buyer, and you are the seller, and you sell it to somebody else to make a profit, having already contracted to sell, then you could be in a situation where that those goods are converted. And in those circumstances, there are damages that might arise. And the question there is slightly different from the contract. So in contract, remember, it is to put the innocent party in the position if the contract had been performed. So there is obviously a situation where somebody might make a profit out of a contract, and therefore under contractual damages, that profit can be claimed. Whereas in tort, it's to put the innocent party in the position as if the act had not been committed. So in those circumstances, the losses that can be recovered are those that connect to or flow from some kind of physical damage. So damage to the ship's hull, for example, and damages that flow from that. But what cannot be claimed is pure economic loss. And what that means is a profit that is made from a situation. So that economic loss could not be claimed. So those are the basics of damages. But let's have a little look at sale of goods contracts, just so that we know what they are. And Rosie was asked a very difficult question about when contracts are formed. Under English law, we do not have to have written contracts in order to have a contract, and that can be really terrifying for some people, but it's kind of reassuring in some ways. There is a recent case of the Canadian court, which I think will probably be followed by the English court and other common law courts around the world, where an emoji was sent in response to a quotation, which was a thumbs up emoji, and the court held that a binding contract had been formed because of that thumbs up emoji. So it's really quite possible to form a contract on quite slim and small communications. And we know very well that we use social media all the time, and social media contracts, a lot of people think, well, social media doesn't really count. What really counts is the signed written agreement. Well, and I think many of you are aware of this already, it is not exactly the case under English law. Some relevant pieces of legislation in England, it's the Sale of Goods Act 1979, and that is a very sort of standard act. It has very few implied terms, so there are a few terms that come in by virtue of the law, but generally speaking, under English law, what you write in your contract is what you have. So the questions about force majeure earlier, the important thing, and GAFTA puts this fairly and squarely in its standard forms, is that if you want to have force majeure, it must be in your contract. If it's not in your contract, then you're not entitled to rely on a force majeure argument. And so that is quite different from, say, other systems of law. For example, I've done a number of things under French law, and under French law, if you describe things specifically as force majeure in your contract, then under French law, they are not, in fact, force majeure. So force majeure has a very different kind of concept from civil law to common law. I've also put on the slide the Convention on the International Sale of Goods, which is obviously a very important international convention in relation to sale of goods. It does not apply under English law. But interestingly, for example, Hong Kong, which has followed the English law position very closely for a very long time, has recently enacted the convention into its domestic legislation. So if, for example, you wish to contract under Hong Kong law for your sale of goods contract, now you would have to specifically exclude the application of the Convention on the International Sale of Goods. Otherwise, you would end up in that situation if you wanted to. But many people like the convention, and it remains in international law. So in terms of the sale of goods contract, the actual contents of the contract do come from a number of different sources. People rely very heavily on standard forms and incorporation of standard form terms. There are some implied terms from the Sale of Goods Act, but we also rely on international, the Incoterms. We stick FOB, CIF in our contracts all the time, perhaps without thinking about them too closely. So shipping and sale of goods. Now, in many ways, they're two very separate and distinct areas of law, but obviously we can't have the shipping without the sale of goods because we need those goods to be transported. And so there are a number of crossover terms that are very close. So you'll see that on this slide, I've just put those things that are similar and overlap. And that causes some of the complications to the shipping and the sale of goods, damages calculations, and recovery options. So I'm going to run through now, just so very briefly, some of the broad claims. Now, we don't have time to deal with all of the claims, and I'm sure you will have questions for me in the question session, and I'll endeavour to answer them as much as possible. But for example, we were talking earlier about failure for the shipper to bring alongside cargo. But of course, there are circumstances where an owner either fails to provide the ship or fails to provide a ship of sufficient capacity. And in those circumstances, the charterer of the ship will be entitled to damages. And the amount of damages that they are entitled to recover would be the cost of transporting the goods by another means. So if it was necessary to charter in a new vessel, then that new charter rate would be recoverable, although the amount of the original charter rate would have to be set off against that. There are also circumstances where the capacity of the vessel is not sufficient to load the contracted quantity, and in those circumstances you'd see the damages is calculated in this way. So the contract rates of the freight on the short-loaded cargo less the market rate of the freight on the short-loaded cargo, but then added back in are those other losses which are incurred by the charterers, the sellers or the buyers, due to the delay in shipping the additional portion of cargo. I also thought it was worth mentioning liquidated damages. This is really a fancy term just to say it's a pre-breach calculation of compensation or of damages that should be paid in certain circumstances. And the one that we deal with all the time is, of course, demurrage. Demurrage is a liquidated sum. It says if there's a delay either to the shipment or to the loading under the sale contract, then demurrage is payable at a certain rate. And in those circumstances, the the pre-agreed amount is called liquidated damages. Now, the question is, are those always claimable? So under English law, and I put English law and Hong Kong law up there just to give you a little bit of contrast. So the test now under English law is whether those liquidated damages are not extravagant, exorbitant, or unconscionable. It used to be that there was a rule against penalties, so that if liquidated damage was not considered to be a genuine pre-estimate of loss, which is the Hong Kong position, then that could not be claimed. But there have been some recent cases where that's no longer the case. So you don't have to say this is a genuine pre-estimate of loss, but it could end up being some kind of preventative measure to try and prevent somebody breaching the contract. And as long as there's a legitimate interest in protecting that, those liquidated damages will be claimable under English law. Just very briefly, this is kind of very straightforward. We've got a delivery of damaged goods, the value of those goods less of the goods in their sound quality less the value of the damaged goods, and that differential will be the damages. Now, when we're talking about shipping claims, there's one very important thing to bear in mind. If your claim is against the ship owner, then there's likely to be a limitation of that claim amount as dictated by the Hague Rules or the Hague-Visby Rules. So it's very important to look at the transport document. And specifically for bill of lading holders, the bill of lading will incorporate either the Hague or the Hague-Visby Rules. And that will allow the ship owner to limit their liability in terms of the value of the payout to a cargo claimant. And here on this slide, we've just got the same issue about delay in delivery. In those circumstances, it's the difference. So you've got a market shift issue. So if the market has fallen significantly in the delay, in the time that the delay has happened, there is likely to be a claim for damages. But one of the things to bear in mind, of course, is if the delay has caused an increase in the market rate, then it may be that there's no damages to even claim. And how do we know what the market value is? Is it the price that the cargo's agreed, the owners agreed to sell the goods to a third party? Well, the answer to that is very quickly no. It's only evidence. But it's not necessarily a substitute for market value, and arbitrators and judges will take evidence on what the market value is of the goods, and then they will make an assessment on the basis of evidence that's put before them. Just very, very briefly, in terms of sellers' remedies under the sale contracts, so moving to sale contracts away from shipping contracts, there are sections of the Sale of Goods Act that help us understand what kind of breaches and what kind of remedies that parties may have. So, for example, if a buyer wrongfully or neglects or refuses to pay for the goods, for example, an action can be brought for the price. That's pretty straightforward. But where there are damages for non-acceptance, then there would be a measurement, and this is set out in the Act, the estimated loss directly and naturally resulting in the ordinary course of events from the buyer's breach. So here again, we would go back to the principles as set out in Hadley and Baxendale and say, what is it that naturally arose from the buyer's breach? In relation to non-delivery, where, for example, the seller has refused or failed to deliver the goods. So again, the estimated loss directly and naturally resulting in the ordinary course of business. And how is that measured? Well, that is measured by looking at the value of the goods if they had if they had been delivered at the time and the place where they should have been delivered. So that is the measure of damages in those circumstances. Of course, there are breaches that happen quite regularly in relation to breach of warranty. So in terms of quality, defective quality, and those going back to first principles, of course, are what is the difference between the value of the goods if they had been of the warranted value or the warranted quality, and the actual value of the goods when they were delivered. Of course, there are possibilities of zero loss, and in those circumstances, it can be quite difficult to actually work out what the losses were. Finally, I just wanted us to have a look at this particular case, Sharp Corp and Viterra. It was a recent case of the Supreme Court covering a GAFTA contract. And in these circumstances, the question was about whether the GAFTA default clause gave the innocent party the right to sell or buy as against the defaulting party. So the question is, does the actual or the estimated value of the goods on the date of default refer to either the market value of the goods when they were rejected, or B, the value of the goods if a substitute contract were entered into on that date? So it was a C&F free out contract, and you can see that there was a significant differential in the value. So Viterra entered into 2 contracts on C&F free out terms to sell lentils and peas to Sharp from Vancouver to India. And each contract had a non-payment clause that provided that in the event of non-payment, the buyers would cooperate with the sellers to resell or transfer the goods to a new buyer. And this was confirmed by the express terms of the contract. So just a quick timeline here. So January 2017, contract of sale. June 2017, the goods were discharged, but the buyers had not paid. So in November 2017, default was declared. And in that time, the Indian government had imposed import tariffs on peas and lentils. In December 2017, GAFTA proceedings were commenced, and finally in February 2018 the cargo was released and resold. The increase in the import tariffs greatly increased the value of the goods. And so when the cargo was resold in February, the issue between Sharp and Viterra was who should benefit from the increase in value of the goods. So the question is, what is the meaning of actual or estimated value of the goods? You can see it's quite a small question, and yet it became really quite important. And the reason it became important is because the amount of damages that were involved. So should the assessment date be the date on which the goods were discharged but the buyers had failed to pay, or the relevant date being the date of contract for the purchase? Just a word to note there, the resale price is usually irrelevant to the question of determining the date on which the damages should be assessed. So, what did the Supreme Court hold? So the Supreme Court, this had gone through arbitration at first instance, at GAFTA, and to the appeal board. The appeal board found in favor of Viterra and awarded damages on the basis that the value of the goods should be assessed based on the original sale contract date here in B, and without any evidence of a market of CF free out Under terms, the board preferred Viterra's evidence that a theoretical cost of buying the goods FOB plus the market freight rate for transporting those goods was sufficient. So Sharp's appeal to the Supreme Court firstly was rejected by the Commercial Court. The Court of Appeal also rejected Sharp's claim. And finally, the Supreme Court made its ruling. And the Supreme Court ruled that damages for non-acceptance of goods should be quantified by valuing the actual goods left in the seller's hands as is where is. So the market price at the place where the goods were on the date of default. So here. At A. So in the present case, the sellers were left with cargo which had been landed, customs cleared, and stored in a warehouse in India. In those circumstances, the value had increased because of the imposition of taxes, and became clear the market in which it would have been reasonable to sell the goods instead of a sale in the international market involving extra costs of re-exporting, etc., etc. So this is an interesting case because, of course, the whole of it really turns on the value of the damages. And it just really demonstrates how important it is to have an early idea of what damages might be claimable. Alexei, I'm going to stop there. I think I've gone over time a little bit, I'm afraid, but I hope that has been interesting to everyone.
Andrew, thank you very much. It was very interesting. Of course, we have not a lot of time for the questions and answers, so I will ask maybe 2 or 3 of them. The first one, if waters enters in the container en route and damaged all the goods, there is no insurance from the customer. Can we, as customer, still claim our loss from the shipping company? Very practical.
So, yeah, it's a very practical question and a really good question. Thank you for asking it. It's if you are the cargo interest, that's where your legal right to claim is. So whether or not you have insurance doesn't change your right to claim. So you as the cargo interest have absolutely the right to sue the ship owner or the carrier under the bill of lading in order to recover that loss. And if you did have insurance, basically the insurer is just taking over your rights. So the insurance company pays you and then takes over your right to claim from the ship owner.
Yeah, thank you, Andrew. The next one in Russian. Andrew, you have the second slide about the book, about the damages. So this the second question is about the books also. Can you recommend some book regarding the English contract law and where I can buy the treaty of contracts? So as to the treaty of contracts, please contact me directly. You can find my contact details on the Interlegal's website or in follow-up emails. But the first part of the questions I will address to Andrew. What can you recommend from the books regarding the English contract law, let's say?
Okay, so
I don't know, for lawyers or for businessmen, I don't know.
There are lots of books on English contract law. I would say that the leading textbook is called Treitel, Treitel, on contract. That's written by the professors of Oxford University. It's used by every law student in England studying for contract law, and it gives you a really good introduction. It is not specific to shipping contracts. the practitioner textbook, which is really good, is called Benjamin on the Sale of Goods. But that's 2 books that are this thick. And really, my recommendation would be in those circumstances, if you've got specific questions, you speak to Alexei, because he would be able to access that through. We have a lot of databases as lawyers, and we can access these books online.
Yes, thank you. The next one. If a contract limits liability, would that be upheld in the event of the criminal act or willful negligence? Could it fall
Yes.
on the unfair contract terms acts if included in terms and conditions which cannot be negotiated?
Yeah. So there are several questions going on there, which are I'm going to struggle to answer them quickly, but I would say that in terms of limitation of liability, parties are able to limit their liability for a number of things, which includes negligence. So you can limit your liability for negligence. Obviously, if you do this, it must be by very clear words. You can't just say it's a general exclusion clause and I exclude all my liability whatsoever. That includes negligence. You have to mention negligence specifically. In terms of criminality, the answer is definitely not. You can't exclude your liability for being a criminal. In terms of willful misconduct, this is something that is debated constantly under English law. And what does willful misconduct really mean? Now, if it's something that amounts to a criminality, obviously it falls into criminal law. If it's something that is bigger than negligence, then it looks like a deliberate breach. And there are circumstances where limitation may be possible. So, for example, if you look at some of the limitations in the Hague-Visby rules that are set out, it can seem like deliberate acts are excluded. And there was a very interesting case involving a crew member. I think he was the chief engineer or something. He went a little bit crazy on board. And he lit a fire on board the ship, and obviously the fire damaged the cargo, damaged the ship, etc., etc. And the question was whether the ship owners could exclude their liability for damage by fire under the Hague-Visby rules, and the courts upheld it. They said, yeah, they could, even though this guy was like an employee of the ship owner, and he's lit a fire on board, they were still able to limit their liability.
Thank you. The next one I will translate. If there is no detention clause in the charter party, can still the ship owner claim detention, for example, for awaiting of the instructions for the issuance of the bill of lading?
The short answer would be yes, they're able to, but it may be you'd always be looking at the fact and degree and the circumstances, and so it may not be as powerful as people think it might be.
Yeah. Thank you, Andrei. I want to say to Alena Kovalenko that her question cannot be answered without having the contract in hand. So please contact us, and we will speak how to help you. Andrew, thank you very much. I think it's enough about the damages. Once again, let me remind to all our participants that the video, together with the contact details, together with the slides, you will receive within a day after this webinar, and we can move forward. George, we already heard about the default, we heard about the damages, and what should we do if we have damages, but our counterparty doesn't want to pay? Can you give us some recommendations? The floor is yours.
Thank you, and hello everybody. It's a pleasure to be here, and it's a pleasure also to see my colleagues who I've also not seen for a while. We used to travel to Odessa, and we're glad to be able to join you now, at least online. So this is the subject of the talk is disputes do arise and what to do then. And so the idea is really here just in this talk just to give an overview of some tips, suggestions based on my experience. I've handled a lot of claims, and I also sit very often as an arbitrator under the LMA terms and other institutions. So based on this experience, I thought there could be some helpful tips that I could share on what's the most efficient ways to resolve some of the claims and some of the mistakes that I see sometimes. What are the options? Okay, so these are some very common means that the parties engage in to resolve their disputes under maritime claims. The first step usually is some sort of negotiation. And these are increasingly, I think, as all the speakers have mentioned, it's now quite commonplace that these take place through, WhatsApp or Telegram, sometimes in person, sometimes on the phone. But WhatsApp and Telegram are really quite often used. And just to repeat what the other speakers have said, which we all agree with entirely, this is really oftentimes seen as an informal means of communication. It doesn't really count. And so, I'm going to discuss that a little bit. Next step is maybe writing a letter of claim or what we call maybe a letter before action. Another option is to try to seek to obtain security for the claim or freezing some assets, mediation, arbitration, and sometimes court. So I'm going to touch on all of these and some suggestions for all of these. So tips on negotiation. So consider always the overall commercial relationship. Egos sometimes come in the way of that, and sometimes it becomes more about a search for justice rather than the commercial relationship. And so it's very important to bear in mind what the overall commercial relationship is. Appeal to an objective standard. So it's not about some I'm right or he's wrong. It's about what does the contract say? And really this is what constant references should be made on what the actual contracts say. Always be courteous and avoid aggressive language. This is common sense, but oftentimes we don't see it in practice. In very general terms, a rule of thumb, it might be that even a very strong, solid claim could be settled at a 20% discount. That will often be commercially advantageous if the payment is made quickly and without further disputes. This is by no means a rule of law. It's just based on my experience, but there's been very rarely a claim which, if there was an 80% paid the next day, will depend, of course, on the size of the claim. But in maritime disputes, that is often the case. So be prepared to make a concession, even if there's no basis for it, if that's going to result in a quick payment. These exchanges, as we said, the WhatsApp or Telegram exchanges, they carry the same weight of evidence as an email or a hard copy letter signed in blue ink. There's no difference in terms of evidence. So be careful what you write. And although these are side communications usually, remember that they carry exactly the same weight of evidence, and they are disclosable, and they can end up before a tribunal or a court. So it's very important. Now, that doesn't mean that you can't engage in negotiations, and so this is why this rule of without prejudice exists, and it's often very much misunderstood. And so I just wanted to discuss a little bit about what actually without prejudice actually means, and how it can be properly used. So what is without prejudice? So according to English law and practice, correspondence which is labeled without prejudice and is actually without prejudice should be correspondence between the parties, which is a legitimate attempt to resolve the dispute commercially. So the purpose of this is to allow the parties a means to communicate without prejudicing their legal position. So if, for example, I write in and I say, okay, I'm willing to offer a discount if we can settle this claim, it doesn't mean that you're accepting that that discount is the amount that you're legitimately and lawfully able to claim. You can still claim the full amount, and nobody needs to see that correspondence, particularly a tribunal or a court. So when you label correspondence without prejudice, what you're saying is this is correspondence which will not be allowed to be shown to a court or tribunal. It's just between us, it's private, and it's only for the purposes of amicably resolving this dispute. If we didn't have the without prejudice rule, then parties would be unable to communicate and make concessions without having those concessions being shown to the court. So that's what without prejudice is about. And so negotiations should always be labeled without prejudice. Now, how do you label a practical question? How do you label what conversation without prejudice? So it's a good question, and I think if it is actually without prejudice, it doesn't mean that, and if it's not labeled, it still doesn't mean that it can be shown to the court, but it's much more harder to identify. So even just putting a WP before the text message that you're sending, those two letters would be sufficient, and I think that's very good practice. Also, there's without prejudice save as to cost, which basically means that's correspondence which cannot be shown to the court or tribunal when the tribunal is assessing the merits of the claim, but it could be shown when it comes to that court or tribunal assessing costs. Basically, here you're saying, I'm being very reasonable, I'm trying to avoid this dispute, and if you're acting unreasonably, then I'll be able to show this to the tribunal and the court. So that can be effective sometimes. Next step is tips on writing a letter of claim or a letter before action. Now, in England, before going to court, there's something called these pre-action protocols. And these are basically steps that the parties that are expected to take before going to court. As you all may very well know, going to court in England is very much seen as the last step, not the first step. Now, these pre-action protocols can be quite informative and very good practice, even if you have an arbitration clause. So essentially what these are is the potential claimant should set out their complete claim, all the facts, the complete legal basis, and all the documents in support of that claim, and send it to the other side. This is very much part of the strategy of I'm giving you all the cards that I have. This is the complete claim that I have. This is the basis for it. It should have the legal basis carefully set out. And then the other party is required in response within a reasonable period, usually between 14 to 30 days, to set out their full position together with all of their supporting documents. And the purpose is to allow both parties to see the full claim of the other, to take legal advice, to assess the claim, and the purpose is to encourage settlement. There's no reason to wait until you're in the arbitration or in court before setting out the full legal position of your claim and gathering all the documents. You may actually find out as you're drafting the letter before claim that maybe there's something you've overlooked. Maybe you don't have all the documents you thought you had. So it's good to do this early. It's a very good exercise. It's very good practice. And generally, when the other side receives, a formal, let's call it a formal letter before claim, even before arbitration is commenced, they're more likely to take that seriously and are able to assess quite carefully what the position of their claim is. The next step, or at some point, another option is obtaining security for your claim. Interlegal has a lot of experience with this. And I'm sure that, we all know that this can often lead to the resolution of the dispute. Do not underestimate the amount of security needed. You might think that you have a claim for, let's say, 400,000, 500,000, but don't forget to include all the other, the interest on that, potential costs. So there's nothing wrong with, arresting a vessel, for example, getting the security, having that posted, and then you find out that you're undersecured. So aim for something which is reasonable, but on the high side, of course. Consider very carefully the cost of obtaining security. This can sometimes be costly. Do not underestimate the release of that security from courts. I'm involved in a case now where, we reached a settlement a year ago, and we're still in the process from various courts around the world of getting the security back and returned to the parties. So it can be quite a long and cumbersome process in getting that security released. And when you're obtaining security, don't forget that you will oftentimes be required to post counter security. So doesn't mean that you don't need to put up some money yourself as the claimant. Mediation, we all know what mediation is. It's the intervention of a third party or mediator into the dispute to assist the parties in negotiating a jointly acceptable resolution of the issues. Of course, the mediator cannot impose any solution on anyone. The mediator doesn't have the power to decide anything, but there is a very effective dynamic of having a third neutral party, experienced mediator to assist the parties. This is, as we know, increasingly popular. It is always held without prejudice. Anything disclosed in the mediation cannot be then produced to a tribunal. They can be conducted virtually, has very high degrees of success, can often be concluded within a day, and this can result in significant cost savings and quick payment. If you agree a settlement with the other party is much more likely to pay than if you're chasing them around the world trying to enforce an award. Arbitration, tips on commencing arbitration. Most important tip is read the arbitration clause in your contract. They come in huge varieties of versions, often not making any sense, often contradictory. So it's very important to read very carefully what the arbitration clause actually says, and read what the arbitration rules, assuming, and hopefully some arbitration rules are referred to, read what those say. This is something that a lot of people don't do. Make sure you use the right arbitrator. Don't necessarily always go for the big names. Think very carefully about your claim. Who's going to have the time to deal with the claim? Who's going to have the capacity? Who's going to deal with it quickly? And who's going to listen to your side carefully? And this is very important. You might not win or lose, but you want to make sure your arbitrator is paying very careful attention to all of your arguments and has the time to carefully deal with your claim. Make sure you actually appoint your arbitrator. There have been some, I've seen some very horrible situations where an arbitrator was approached, was said, would you accept? Can you check for conflicts? The arbitrator goes back and says, yes, I would accept. I don't have any conflicts. And then nothing is done after that. A notice of the appointment is sent to the other side, and it turns out the arbitrator was never appointed, and so therefore the tribunal doesn't have jurisdiction, and it can lead to huge costs, consequences, simply by not using the words, I hereby appoint you as the arbitrator. And that needs to be done before notice is sent to the other side. Speaking of notice, when you send your notice of the appointment, make sure you send it to the actual party. Don't send it only to brokers. Don't send it only to P&I clubs. P&I clubs don't have a general authority to accept notices. So I've seen arbitration awards not be enforced by courts because the party was not actually actually given notice. The broker was, and this could involve things like just going on the website and sending notice to the contact information, which you find on the website, not just the party who you've been engaged with in negotiations. And it's good practice to send a hard copy by courier at the very least to the party, because many courts around the world want to see that there's been proper notice. And of course, not having proper notice is one of the means for not enforcing an award under the New York Convention, Article 5. Consider carefully the cost of the arbitration. This can range from 5,000 to over 100,000 just for the tribunal, and the time, which can be 6 months to several years. Carefully consider enforcement of any award. Can you enforce this award? And just because you commenced arbitration doesn't mean that you shouldn't always be reaching out to the other side, possibly on a without prejudice, savings to cost basis, making them offers as the process goes through. Continue to make them offers to settle at rates which are acceptable to you, of course, to avoid the arbitration necessarily proceeding. And finally, if you do not have an arbitration agreement in your contract, then you need to consider which jurisdiction you'll commence a claim. If you're commencing a claim in England, the costs can be quite high. The court fees now for claims, this is just what you pay to the court to issue the claim form, is £10,000 for any claim over £200,000. So that's a pretty chunky court fee to pay, as opposed to commencing arbitration, of course. Consider the difficulties of just serving that claim form. A lot of people don't consider this. So once you issue the claim form, if the opponent is not resident in England, then you need to find a way to formally serve that document abroad. And I've had experiences where it has taken over 6 years to serve the claim form. The claim form expires after 1 year, so an application needs to be made to the court. Everything needs to be translated into the foreign language. It goes through various court services and through the Hague Convention for service of foreign documents abroad. So this can be a very long and cumbersome process, just simply getting the claim off the ground. So this is very important to consider. Can you enforce any judgment? Is there an agreement between England and another country for the mutual recognition and enforcement of court judgments? There may not be. And consider also the possibility of issuing a statutory demand or a winding up petition instead. So if what you're talking about is really just a straightforward debt, which isn't really disputed, the other side's just not paying. If that's an English company, then you can issue a statutory demand for extremely inexpensively, less than £1,000, and that simply requires them to pay within 21 days, failing which you can apply to the court to close the company, and that involves freezing their assets, their bank accounts, the directors. So there are serious consequences for the directors of the company. So this is a very inexpensive, quick and easy way of obtaining payment under circumstances where it's not disputed, and this is just a straightforward debt. So that's everything that I had to say, and I'd be very happy to take any questions if there's time.
George, thank you very much for this. We have, in fact, a lot of questions. We received them during the registration, but really I can separate them in two big groups. One of them is about the average time and costs of the arbitration, and we noted that you already mentioned the range between £5,000 and over £100,000, and from 6 months to years. If you want to add something here, please add. And the second big group is about the enforcement of the arbitration awards. Just so let it be these two big questions
Sure.
for you, because all other questions are about the same. Thank you.
So under the LMA rules, there's no set tariff for what arbitrators are paid. So an arbitrator under the LMA rules can essentially charge, whatever they like. That hourly rate should be, it's good practice that hourly rate is known to the parties at the appointment stage. The typical, the established, full members will typically charge between, let's say, about 350 to maybe 400 per hour is what I've seen. But if you're going to be appointing a very high senior KC, then they might charge 800 per hour. So that's one factor to consider. Another factor to consider is the procedures which are adopted, and this is really where the parties themselves can play a big role in reducing those costs. So, consider raising a preliminary issue. If there's a preliminary issue over is the claim time barred, then this can be done quite easily on very little facts, and if the claim is time barred, you don't need to deal with the rest of the claim. So these types, you always keep a lookout for the possibility of knocking out claims early, or pursuing claims, and getting some particular issue determined quickly. Don't leave it to a sort of autopilot. Too many parties, I think, just say, well, I've left it with the lawyers. And, lawyers are very good, usually, but you need to be involved in this process and always be looking about what the costs are and what do I really want to achieve here. The beauty of arbitration, which people don't, and arbitrators and parties don't often appreciate, is that it's highly flexible. And it's designed to be tailor-made to the particular dispute. So to use that to your advantage, there's no set procedures that you must follow. It's always in the hands of the arbitrator. The arbitrator is under a duty under Section 33 of the Act to ensure that all procedures will be cost-effective, as well as just and to the parties.
Thank you. And the second part about the enforcement.
So what's the success rate of enforcement of arbitration?
Just in general, maybe some words about the convention, something like that.
Yeah, exactly. So as you all know, probably know, there's the New York Convention, which is signed by almost every country in the world. So arbitration awards are far more likely to be enforced around the world than court judgments are, as a general rule. And I think, generally speaking, as long as you comply with and you're aware of many of the formalities, which I think is often underestimated. We think, well, because it's English law, we're in London, so we can send an email and that's fine. Good practice is, if, for example, you plan on enforcing in Ukraine, then go to a law firm like Interlegal from the very beginning and say, look, this is what we plan on doing. How can we serve this notice to make sure that it's consistent with what the courts are expecting there? And maybe an email is not enough. So what are some other things? How is when the award is produced, what can I tell the arbitrators that they need to do in terms of communicating that award to the other side? So there's lots of things that could take place. Do I need an oral hearing? There may be some jurisdictions where an award on documents alone maybe doesn't carry the same weight as one where there's been an oral hearing. So it's good to get advice from the place where you want to enforce, not after you get the award, but even before you commence the arbitration, to make sure you comply with all those procedures.
George, thank you very much. We have to finish. Thank you to George, to all the speakers today. And also thank you to our participants. I hope the topics we choose are interesting and deep enough for your practice in business or maybe as lawyers also. So please give me a feedback about this webinar in order to make our next webinars better and better. And now I pass my microphone to Denise for final closing remarks. Thank you very much, Alexey Remeslo from Odessa office.
Yes, I would like to say thank you to all the speakers, and I guess no, I'm sure that we achieved our main goals, and there were a lot of insights, and they were very practical. And so, if our participants and our attendees have some questions, and they will have it after, so they can write to us, and we can help you to contact our speakers, and you can also write for Alexei in Interlegal, and everybody, all the participants, all the registered attendees will be followed up with the recording and with the speakers' presentations. Thank you once more, and speakers, my respect to you. Thank you. Bye.
Thank you very much. Goodbye.
Goodbye.